Congress created Medicaid in 1965 to subsidize state healthcare systems for people unable to afford healthcare. South Carolina has a law that prohibits public funds being used for abortions. For this reason, South Carolina disqualified Planned Parenthood from participating in the state's Medicaid system. It should be no surprise that Planned Parenthood South Atlantic sued. The Supreme Court's decision, though, may surprise you. So we'll look at that next on the Constitution Study.
Lovely neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach the righteous generation be free. I'm glad you could join me today. You know, Planned Parenthood generally evokes strong emotions, for or against. So when Planned Parenthood sues, there's a lot of emotional content to the arguments. Now, I found this to be an interesting decision. I think you will as well. And before I get to it, I want to remind you that you can find all of my sources, my links to my sources, in the article on the website, constitutionstudy.com. Now, I'll talk more about the website, ways you can support the work that we're doing at the end of the program. But for now, let's take a look at this case involving Planned Parenthood and Medicaid. Let's start with a little background on this case. Congress created Medicaid in 1965 to subsidize state health care for families and individuals whose income and resources are insufficient to meet the cost of necessary medical services. Just where in the Constitution is Congress granted the power to subsidize state health care for any reason? It certainly isn't the General Welfare Clause, Article 1, Section 8, Clause 1, which reads, Congress will have the power to lay and collect taxes, duties, imposts, and excises to pay the debts and provide for the common defense and general welfare of the United States. These subsidies are not for the general welfare of the United States, but for some of the people of the United States. Actually, since the subsidy was not given to the people, it's actually for the welfare of the several states. Medicaid offers states a bargain, federal funds in exchange for compliance with congressionally imposed conditions. So Congress offered states funding they are not authorized to spend in exchange for following their rules. Isn't the offering of an illegal emolument as a consideration for action not the definition of a bribe? From the Free Legal Dictionary, a bribe is the gift or promise which is accepted of some advantage as the inducement for some illegal act or omission, or of some illegal emolument as a consideration for preferring one person to another in the performance of a legal act. So this bribe starts out with submission to Congress's illegal demand to regulate a state's healthcare system. To participate in Medicaid, states must submit a plan for medical assistance satisfying over 80 conditions in Section 1396AA. If a state fails to comply substantially with any condition, the Secretary of Health and Human Services may withhold federal funding under Section 1396C. Now, states have a laundry list of conditions they must comply with in order to be offered the bribe from Congress. And if a state doesn't comply to the HHS Secretary's satisfaction, they lose their bribe. This case involves the Any Qualified Provider provision in Section 1396AA23A, which requires states to ensure that any individual eligible for medical assistance may obtain it from any provider qualified to perform the service who undertakes to provide it. The provision does not define qualified, leaving that to states' traditional authority over health and safety matters. The law states that any individual eligible for medical assistance can get it from any provider qualified to perform the service. However, the law doesn't define qualified, leaving that up to the states. More on that in a minute. The question is whether individual Medicaid beneficiaries may sue state officials under 42 U.S.C. Section 1983 for failing to comply with the Any Qualified Provider provision. While the question before the court is, can individual beneficiaries sue, there's a lot more to this case. We've looked at background for the case. Now, let's look at the relevant South Carolina law. Planned Parenthood South Atlantic operates 2 clinics in South Carolina, offering a wide range of services to Medicaid and non-Medicaid patients. It also performs abortions. Citing state law prohibiting public funds for abortion, South Carolina in July 2018 determined that Planned Parenthood could no longer participate in the state's Medicaid program. No one is saying the Planned Parenthood of South Carolina has to shut down their clinics or stop providing abortions, only that they are not eligible for the state's Medicaid program. This is because of a state law that prohibits public funding going to abortion. At the same time, the state took steps that, it said, would help ensure that other providers would continue offering necessary medical care and family planning services. The states did not abandon people seeking medical care and family planning services. The state took steps to make sure they could receive care. That wasn't good enough for Planned Parenthood or for one of their patients. Planned Parenthood and patient Julie Edwards sued, claiming the exclusion of Planned Parenthood violated the any qualified provider provision. Now, however, the state showed that Planned Parenthood was not qualified to accept public funds. They may have been qualified to provide other services, just not with public funds. Edwards alleged she preferred Planned Parenthood for gynecological care but needed Medicaid coverage. They brought a Section 1983 class action to vindicate rights secured by the federal Medicaid statute. The fact that Ms. Edwards prefers Planned Parenthood doesn't mean she has the right to get services from them paid for by the public money. No one in the state of South Carolina is preventing her from getting services from Planned Parenthood, only that it's not paying for their services. Her claimed right to Medicaid funding doesn't include using it at unqualified establishments. Section 1983 allows private parties to sue state actors who violate their rights under the federal Constitution and laws, but federal statutes do not automatically confer Section 1983 enforceable rights. This is especially true of spending power statutes like Medicaid, where the typical remedy for violation is federal funding termination, not private suits. Title 18 of the United States Code, Section 1983, is the law Congress passed affirming a person's right to sue someone for a deprivation of rights under color of law. Now, while the court focuses on whether or not the Medicaid law established rights enforceable by Section 1983, I think there's a more fundamental question. Does Medicaid law create a right for someone to receive medical care at taxpayer expense, whether or not the state lists them as a qualified provider? The district court granted summary judgment for plaintiffs and enjoined the exclusion. The Fourth Circuit affirmed. This court then granted certiorari, vacated, and remanded in light of Health and Hospital Corporation of Marion City versus Tlefsky, which addressed whether another spending power statute created Section 1983 enforceable rights. On remand, the Fourth Circuit reaffirmed. So both the district and circuit courts found for Planned Parenthood, but the Supreme Court vacated based on the case Health and Hospital Corporation of Marion City versus Tlefsky. Tlefsky is a case where the court found that a congressional act did not create a Section 1983 enforceable right. In this case, the court held Section 1396 AA 23A does not clearly and unambiguously confer individual rights enforceable under Section 1983. So this court doesn't think that the Medicaid Act created a right enforceable by Section 1983. Now, Justice Thomas agreed with the court decision, but wanted to expand the scope of the case. Individual plaintiffs may invoke revised statute Section 1979, 42 U.S.C. Section 1983 to sue state or local officials who have deprived them of any rights, privileges, or immunities secured by the constitutional laws. In other words, Section 1983 provides a mechanism for plaintiffs to enforce constitutional or statutory provisions that confer personally held federal rights. The court correctly holds today that Section 1396 AA 23A of the Medicare Act is not such a provision. Its decision properly limits plaintiffs' ability to bring 1983 suits premised on conditional spending legislation, and I join in full. Justice Thomas fully agrees with the decisions of this case, so why write the concurrence? I write separately because it behooves us to re-examine more broadly this court's Section 1983 jurisprudence, which bears little resemblance to the statute as originally understood. In appropriate cases, we should reassess Section 1983's bounds, including its application in the spending context and our understanding of the rights enforceable under Section 1983. Apparently, Justice Thomas wants to expand the court's interpretation of Section 1983. Specifically, should Section 1983 be a method of redress for laws that involve spending? Now, Justice Jackson wrote a dissent to the opinion, which was joined by Justices Sotomayor and Kagan. The Civil Rights Act of 1871 was an exercise in grand ambition. It had to be. In the wake of the Civil War, the American South was consumed by a wave of terrorist violence designed to disenfranchise and intimidate the country's newly freed citizens and their allies. The threat was existential, not just for the newly liberated, but for democracy itself, and required bold intervention. It was precisely because the goals of the 1871 Act were so ambitious that those most committed to the structures it targeted, included many in South Carolina, opposed the measure so vehemently. The Civil Rights Act of 1871 was a grand ambition, but was only necessary because of the unwillingness of southern states to enforce the supreme law of the land. While the threat was serious, that did not authorize the federal government to also violate the Constitution, which created it. A century and a half later, the project of stymieing one of the country's great civil rights laws continues. In this latest chapter, South Carolina urges our court to adopt a narrow and ahistoric reading of the 1871 Act's first section, which is codified today at 42 U.S.C. Section 1983. That venerable provision permits any citizen to obtain redress in federal court for the deprivation of any rights, privileges, or immunities secured by the Constitution and laws of the United States. South Carolina asks us to hollow out that provision so that the state can evade liability for violating the rights of its Medicaid recipients to choose their own doctors. The court abides South Carolina's request. I would not. For that reason, I respectfully dissent. Actually, South Carolina is not asking the court to hollow out the law, but abide by it. Under the Medicaid Act, states, and not the federal government, determine the qualifications for participation in their publicly funded healthcare system. The people of the state of South Carolina, through their representatives, have decided that those entities that provide abortions are disqualified from receiving public funds. Neither Planned Parenthood nor Julie Edwards have a right to direct public health care dollars. Therefore, there is no deprivation of rights to litigate under Section 1983. For a justice who appears so concerned about democracy itself, perhaps Justice Jackson should pay attention to the law rather than her political agenda. Because as a republic, the state of South Carolina has the right to direct their funds within the laws established by the people of the state and their representatives. Since Section 1396 AA 23A of the Medicaid Act does not create a right of a provider to participate in a state's Medicaid system, nor does it create a right for someone to use a Medicaid benefit at a provider that does not qualify, so there is no deprivation of rights and therefore no Section 1983 action. Though I know this is not what those who are Planned Parenthood supporters want to hear, it's the truth. What I would like to know is how many taxpayer dollars were spent, both by the state of South Carolina in the defense of this case and by the federal government for having to try this charade. So the court looked at this case and said, no, the Medicaid Act did not create a right for either Planned Parenthood or one of their customers to have access to Medicaid dollars. They have to be qualified as a provider. The state of South Carolina says if you do abortions, you are not a qualified provider. Therefore, you're not eligible to the Medicaid system. Now, the fact that Ms. Edwards wants to use Planned Parenthood doesn't change that fact. The fact that she needs federal dollars to go to Planned Parenthood doesn't change that fact. She has a choice. These are state dollars. The state gets to choose where they spend them. Yes, they're subsidized by the federal government, but the law strictly states qualified provider, any qualified provider, anyone qualified to provide the service. Well, if the service requires payment and you're not qualified to accept payment, then you're not a qualified provider. I know that's not what Planned Parenthood or Ms. Edwards wants to hear, but that's the law. So as we look at this case, to me, I think the court not only came up with the right answer, I think they got it for the right reason. I point that out because of how often I say that the court got the right answer for the wrong reason. I think they got the right answer. There is no 1983 action. The question is, did the state of South Carolina violate their standards and are no longer eligible for federal tax money? That's it. It's the understanding of the law, again, that is so important to understanding these cases. It's why I take the time to go through them here with you today. Now, if you'd like to find out more about the Constitution Study, maybe buy a book or donate to the cause, just go to constitutionstudy.com. You can find all my articles, all the videos, and a lot of other content that I create and post on the website for your use and information. If you'd like to ask a question, constitutionstudy.com/questions, or just click the Ask a Question button, and you can ask a question. And if you'd like me to answer it on the radio, let me know. If you'd like me to answer it here on the website, let me know. I'll do my best. Now, when you buy something from the Constitution Study store, Well, that money goes to help support the work that we're doing here, because I don't take a salary. In fact, nobody takes a salary. We all do this voluntarily. We pay for all of our own stuff so that we can bring this content to you. And if you'd like to help us by supporting that work, well, that'd be greatly appreciated. You can buy a book, buy a mug or a t-shirt, or just donate to the cause. All they're at the store, but at constitutionstudy.com/shop. You can also support us through our affiliates like Patriot Mobile, America's only Christian conservative wireless provider. They believe what we believe. They support organizations that are defending our rights, not organizations that are trying to destroy our rights. Best of all, you get great 4G and 5G coverage across the whole country and 100% US-based customer support while supporting me and other organizations that are trying to protect your rights. Just go to patriotmobile.com/constitution, find a plan that works for you, see if you're eligible for a discount. Everyone from NRA members, first responders, and even families with multiple lines are eligible for discounts. And when you check out, be sure to use the code Constitution to get free activation. Once again, go to patriotmobile.com/constitution to join America's only Christian conservative wireless provider and support the Constitution Study while you're at it. And don't forget to use the code Constitution at checkout to get free activation. I also hope you'll share the work that we're doing here, share links to this and other episodes, articles, all the content. I hope you'll share all of it, because that's really how most people find out about us, word of mouth. I hope you bring them along next time, too, when we join for the Constitution Study.